Donald Trump's lawyers, once again, are asking for more from the courts because why? They never, ever want Donald Trump to be held accountable for his crimes. Ever, ever. Every case, 4 separate indictments, 4 separate jurisdictions. Every one of them is dead in the water, including the Manhattan DA case that has now been postponed, the sentencing, until November of this year after the election. Fine, I understand there should be no combination, no commingling of politics and criminal justice, but the United States Supreme Court absolutely made it so that the one case that was going to hold him accountable, the case of the Manhattan DA's office, where he paid off a porn star hush money payments through his personal lawyer, Michael Cohen, and then lied about it by falsifying business records, right? That whole thing in order to hide that information from the American public. He was tried, convicted, 34 counts, was supposed to be sentenced twice. It's already been postponed twice. Why? Because the Supreme Court decided to get involved in this presidential immunity thing and throw a monkey wrench into everything and create new law where there was never law before. Make no mistake, there was no such thing as presidential immunity from criminal prosecution. There should never be any immunity from criminal prosecution, right? It doesn't exist. The only thing I can think of is diplomatic immunity, where there's a diplomat who lives in this country and we can't do anything to them. If something happens, we have to send them back to their country. Why? Because we have diplomats in other countries and we want the same thing for our diplomats, for our citizens. I don't know anybody else who has full immunity from prosecution criminally. Now the president does. So it's shocking. It's surprising. The Supreme Court did it in a just kiss to Donald Trump right before sentencing. So it had to get adjourned. And then now it had to get adjourned again. And why am I bringing all this up? Why am I so mad? Because recently, last week, when the case we thought was finally going to go, September 18th, it was going to happen. And Judge Merchan said it was going to be delayed until November, and I'll remind you why in a second. But the reason we are here today is because that wasn't good enough for Donald Trump. It's not good enough to put this over until November. Why? Because he might lose the election. Hopefully he will. And if he does, he's going to prison. There's no doubt in my mind that Judge Juan Merchan will sentence him to prison and he will go in. And they want to postpone that for as long as possible, hopefully forever from their perspective. They never want him to be held accountable ever, ever, ever. So what did they do? They are appealing in the federal courts again, asking for a stay, and they're just desperately trying to get anyone who will listen to stop the sentencing and not let it go forward in November. And it's just outrageous. It's absolutely outrageous to me that this is happening and that they're even just asking for this. And if I were the Second Circuit, I would smack it down and say, you know what, I'm not getting involved. This is a state court matter. It's not a federal matter. This was personal. This was your personal case about your personal lawyer paying off your personal porn star. It had nothing to do with the presidency. This is nothing that you're immune from. And, you know, the other beauty of this case is that if he does win for presidency, by the way, and he wins the election, God forbid, he cannot pardon himself or dismiss this case, right? He can do that and probably will do it, despite the fact that Joe Biden said he's not going to commute sentence or pardon his son, right? He won't do that. I can guarantee you that Donald Trump will have his Department of Justice dismiss the Mar-a-Lago case if it comes back, and pardon himself, as well as the January 6th case. So, and then the Fani Willis case, of course, is in some nowhere land that who knows if that will ever go. But let's just remind everybody what Judge Merchan said, and then we'll read the letter that Donald Trump's lawyers wrote asking for another adjournment so that even in November he doesn't get sentenced. So this was a decision, an order by Judge Merchan that basically said defendant requests adjournment of his sentence, currently scheduled for September 18th until after the presidential elections. Don't forget, that was Donald Trump's request. Do it after the election. Merchan gave it to him, by the way, but that's not going to be enough for him. It's not going to be sufficient, but I digress. So defendant requests an adjournment of his sentence until after the 2024 election. He argues adjournment is necessary to provide adequate time to assess and pursue appellate options in the event the court denies his pending motion to avoid the potentially prejudicial or politically prejudicial impact that a public sentencing could have on him and his prospects in the upcoming election. So, right? So what he's really doing here is he's saying, I want an adjournment because the sentencing could impact my election. Okay? So now the judge gave it to him, right? But his new letter, you'll see, is now he comes up with a new reason because it's never good enough, and he just changes his story always. So essentially it says he tries to say all kinds of grievances, and he goes on and on that, that it will impact the election, and, that the court is biased, and, all the things that we know he was saying. But the Manhattan DA's office say, you know what, we defer to the court on the appropriate post-trial schedule to allow adequate time to adjudicate this motion. And I said at the time, because I believed it, that the Manhattan DA's office, by saying we take no position as to whether you adjourn this or not, is essentially putting it on the judge and signaling to the judge that, yeah, we kind of agree that there should be an adjournment. We don't want to say that because we want there, we don't want to say that because we don't want to look like we're kind of giving in to Trump. So we're just going to defer to the court. Well, the court basically shot them down and said, although you say you defer to the court, that you take no position, you're essentially taking a position and agreeing with the defendant that there should be an adjournment, and therefore he called them out and basically said, so you're not putting this on me, so I'll adjourn it, right? This is what we have to do. So that's what he did, and he adjourned it to November 12th. Judge Merchan is going to render his decision on presidential immunity, right? On whether or not presidential immunity impacts this case at all. He was supposed to do that September 16th, 2 days before the sentencing. But again, he didn't want to prejudice the election in any way. So he's giving Donald Trump what he asked for. No political motivation whatsoever here. To avoid any appearance of anything, we're going to put it over to November 12th. And then November 26th, if there's a sentencing, if I don't dismiss this case or somehow order a new trial, November 26th will be the sentencing. And again, even though this is personal, and even though in other words, this is not part of his job description, this is not part of the core responsibilities, and therefore it could be immune, right? He could be actually immune from criminal prosecution in the Manhattan DA case. There is some evidence that was allowed in, and we've talked about it a lot, that could potentially have been inappropriately allowed in because they were part of his presidential duties or part of his job description, namely some of the evidence involving Hope Hicks. I won't go into it in detail, but the judge here is going to rule whether or not he should have allowed some of that evidence in. I think Hope Hicks is going to be the main thing that he's going to grapple with. And then he's going to do what's called a harmless error analysis. And if it was harmless because there was so much evidence against Donald Trump, he will say the conviction will stand. If he decides that no, this might have been unfair, and it was so important that the jury might have relied on it, I might have to set aside the verdict and order a new trial. And he could do that. It's not clear what he will do, and it's kind of a tricky decision. I'll give him that. It's not frivolous. And so he's putting it over. He's giving it so that there's more time. And in the meantime, what is Trump and his lawyers trying to do? He's trying to go to federal court and say, you know what? I don't like what's happening in state court. I don't want this to happen in state court. I'm a former president. I should be only in federal court. And so he's asking for something called removal. And so he's gone twice now to Judge Hellerstein in the Southern District of New York and said, this was all part of my job description, so I should have, it should be removed to federal court. Well, Judge Hellerstein has already ruled twice now that no, this is personal. This is your personal lawyer, that in your personal business, your personal porn star, and this had nothing to do with the presidency and your core presidential duties. And so he hasn't removed it, right? So what does the letter say? September 9th, 2024, from Emile Beauvais and Todd Blanche. Apparently they all now work together at the Blanche law firm and represent Donald Trump. And what does this letter say? It is to the clerk of the United States Court of Appeal for the Second Circuit. So it's the federal court's appellate court, right? So Judge Hellerstein, where they're trying to get the case removed, this is the appellate court above that. And it says, we respectfully submit this supplemental authority letter on behalf of defendant appellant President Donald Trump relating to the pending stay motion to inform the court of two developments. On September 6th, first, the district court denied the stay motion that Trump filed on September 4th. So in other words, what Trump asked Judge Hellerstein to do was stay Judge Merchan's case, the state court case. I want you to intervene and stay that sentencing. And Hellerstein denied doing that, okay? And on top of that, like I said, the stated reason was so that it doesn't influence the election. Judge Merchan switched it. But he says, so number one thing that happened, I want to inform you about, is the sentencing got removed, that the immunity motion got moved and the sentencing got removed the way we just described, right? November 12th and November 26th, respectively. You would think that any normal lawyer would then turn around and say, we got what we asked for. So now what could we possibly ask for more, right? We got exactly what we asked for. We got an adjournment, so it doesn't interfere with the election. But what they're saying is it's a stay is appropriate still, notwithstanding Judge Merchan's adjournments, in order to preserve Trump's right to a fair and orderly litigation of the presidential immunity defense in a federal forum, because the significance of presidential immunity doctrine, the federal government, and the public share an interest in that outcome, even if these novel and complex issues are to be addressed after the 2024 election. Gee, all you asked for before was to have it be after the election because you didn't want it to influence the election. Well, now you got it. So now you have to come up with a new reason. Okay, so here's their new reason. For example, President Trump's ability to seek appellate review of the district court's ruling would be irreparably harmed in the absence of a stay, because Justice Merchan could move forward with sentencing and a judgment of conviction before this appeal is resolved. Furthermore, Justice Merchan's current schedule does not allow adequate time for interlocutory appellate review of presidential immunity he is likely to issue before the appeal is resolved, which contradicts Trump v. U.S. Accordingly, while Trump defers to the court regarding whether an administrative stay is appropriate, a stay pursuant to Rule 8A2 is still necessary to preserve the status quo. So what he's basically doing is saying, put it off. I don't want to be sentenced. He doesn't want to go to jail. He really doesn't want to go to jail, even if it happens after the election, if he loses the election. He wants to litigate this forever. And we all know how long the Supreme Court and appellate courts can take if they want to, and they will absolutely do that. So he's trying to get this sentencing put off and sent into outer space, the way the Fani Willis, Fulton County, Georgia case is, and the way the Mar-a-Lago case is, because that's going to go through the appellate process. And believe me, they're not going to be in any rush. This United States Supreme Court is not going to be in any rush, even if he loses the election. So let's see what happens. We'll see what the appellate courts do, but it's never enough for them, never satisfied, and they keep asking for more. It's like you give an inch and they take a mile. So it's very frustrating. Sorry if I'm a little bit fired up, but it's very, very frustrating. It's frustrating enough that this was put over, but now they are trying to have it really never happen. And he just never wants to be held accountable. And tell that to all the other defendants who commit crimes and are sentenced very quickly and are held accountable much quicker than this and don't get afforded all of these same privileges. So I'm Karen Friedman Agnifilo, co-host of Legal AF and Mistrial. Don't miss our podcast where we go into deep dives on all issues involving law and politics. Thanks so much for listening.
Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.